Welcome to the Commercial Awareness Compass. This is your weekly guide to developing your commercial awareness in a way that goes beyond just the news. Each week we focus on one major news story, breaking it down to help you understand at 3 levels: beginner, intermediate, and advanced. So we're going to break down today's story in a way that's easy to follow and gives you practical insights to use in your applications and interviews. I'm Tori, I'm a future trainee solicitor, and I'm joined by Emma, an experienced commercial lawyer. Today's session, we're actually lucky because I've been saying that we're going through one story, but actually we're going to talk about a few different ones because today we're talking about settlement agreements. So as we go through the beginner, intermediate, and advanced levels, I encourage you to really pay attention to how each explanation builds on the last. So we're first starting with understanding the basics of what's going on here. Then you want to be thinking about how businesses and industries are impacted and what is the role of law firms in assisting. And then finally, we're thinking about strategic thinking that goes into law firms helping clients manage these challenges. So let's get into it. Emma, do you want to just give us a bit of an overview of what we're discussing today?
Of course, thanks, Tori. So as you mentioned, there's a few different stories that will go into this, and I'm sure stories that the audience will have of their own and different examples of what they might have seen. But we are unpacking legal settlements today, so we're going to explore what they are and what they might involve. And there's 2 reasons why I thought we'd go into these, mainly because of the few high-profile cases, some of which you've alluded to, but we will reveal some of those in a little while. And of course, that can relate to this that we're talking about today. But also because there's often a misunderstanding or a speculation about what settlement actually means and what goes into that, including, are we trying to avoid a court case? Why would we do that? So we'll explore those things as well, Tori.
Thank you so much. So you alluded to some high-profile stories that we're going to discuss. So did you want to first just give us an overview of what are these stories?
Happy to do that, yes. So we'll start with Freddie Flintoff's settlement with the BBC. So a lot of you may have seen or have seen advertised the documentary that Freddie's come out with on Disney Plus recently. And whether you're watching that because you're really interested in the legal side or because, of course, it's entertaining and you want to follow what happened, no judgment either way. But obviously, there was a horrific crash that Freddie encountered on set whilst filming for Top Gear. And there's been a reported £9 million settlement there. We don't know, that's not been confirmed. And for multiple reasons we'll get into later on. But yeah, big settlement, high profile case, which we'll look at. Another one is Prince Harry's settlement with the News Group newspapers. So you may have seen the substantial settlement there relating to the phone hacking allegations. And this was mainly around the start of the year in January 25. Now, Prince Harry has, of course, had other court appearances for different things, so don't confuse these ones. But we're talking purely about the settlement with NGN. The publisher did agree to pay over 10 million in damages, so it's another hefty settlement, and there was an apology issued there. And then there was a class action settlement. So class action is where a large body of, let's say, the public come together and bring one claim, one class action together, as opposed to thousands of individual ones. So you've got more power that way. Class action settlements with Mastercard, and the settlement was about 200 million because the lawsuit was for about 14 billion, I think. But there was a settlement reached in December 2024, and then it had to go actually to the Competition Appeal Tribunal. So we're there into regulatory realms there. But this was settled in February 25, which marked conclusion of that huge case as well. So those are the 3. Don't worry too much about the intricate detail of each of them. You're not going to have to remember everything. It's just to highlight 3 examples of high profile cases, and what we'll do today is we'll look mainly at the generic settlement part of those.
Thanks so much. Thanks for providing that overview. I think, like you mentioned at the beginning, our listeners probably have some settlements that they're thinking of too, that they have seen in the news. And even when I was applying for training contracts, one of my commercial awareness questions, I wrote about a settlement agreement. So I think that this kind of situation is really ripe for that commercial awareness analysis. So I think it's really great that we're going to focus on it in today's session. I think that's something that will be good to start our listeners off with as well, is just understanding a bit more about how the process of reaching a settlement goes. So could you talk a bit about the kind of timeline of how this really works in practice?
I can, yes. But first of all, Tori, I imagine the listeners want to know what you wrote about. So I'm going to ask, what was it?
I wrote about a settlement that Google reached related to a lawsuit they were facing linked to privacy concerns from their users.
Ah, big one. Lots to write about there.
Mm-hmm.
Big one. Okay, thank you for that. Anyway, that's the timeline. I didn't want anyone thinking, Emma, why didn't you ask? So yeah, a rough timeline. Now, this is never going to be completely fixed. There's going to be complications and back and forth, but I think it might be helpful to show the main reasons why you might come to a settlement and the timeline that might come from that. So of course you will have individuals who have fallen out, they don't agree with each other, and they are threatening legal proceedings or litigation. So for those that haven't yet come across that term, or have but don't want to ask what it actually is, that's what we do here. We break down those things. Litigation, when something becomes litigious, it's usually being processed through the court. So it's the start of a claim. It can be when you invoke the civil procedure rules, so the CPR, things like that. It's when something gets to a point where you've got some sort of court procedure to follow. Don't necessarily just jump straight to court. Think that there's a lot of pre-action things that might need to happen there as well. So if there's some sort of legal action that will lead to court, think litigation and litigious. So before something becomes litigious, there will be, conversations, commercial conversations. We aren't happy that you've done this. This has happened. We think you're in breach, or we think our rights have been taken advantage of. For example, obviously with the Freddie case, that the crash happened, and then there would have been a discussion around liability. So there's got to be some sort of trigger event as a falling out, two sides or multiple parties disagreeing about something. And then when it gets so far and you've got this disagreement and the to and fro, and lawyers on either side are arguing for each person's case. So Freddie's lawyers might have said that, that BBC, this is your fault. BBC are saying, well, Freddie, there was certain things you should have done and you didn't. Again, as on all of these sessions, we are speculating, we don't know. But that's an example of something that might have happened. And then if you can't get to some sort of agreement through informal conversations, I would say, you might start to threaten actually going to court. And then that does put a lot of pressure on settling. Now, whether the parties in the instances need that pressure of court to get them to settle will differ. So sometimes they'll be like, oh, immediately from the start, we'll settle this, we'll give some sort of payout and we'll negotiate. Other times, like I can imagine, with the Prince Harry settlement and other things that go to court, it might go through certain hearings and things like that before you end up in a settlement, and you might hear it that way around as well. So also don't get confused if the timeline's different. I wanted to highlight that first. So yeah, you'll have some sort of disagreement. You'll talk about it and you can see if it can be settled, and at which point the pressure comes to actually sign this settlement agreement. Just a few of the reasons why you might settle, and at those different times, is to avoid high legal costs. So trials are very expensive. Settlement can reduce financial burden of parties. It can save time. So if you're getting to a certain point, especially in high profile cases where things want to be settled, you'll go through those things. It can reduce risk. So some might decide to go to trial because they think they've got a foolproof case. Others, it's quite unpredictable. These judges can change and you don't know what the decision might be. The advice from lawyers might be, you've got a 60-40 chance. Do you want to risk that? So it might get to that point in the timeline when you go, right, okay, we'll settle. Privacy, obviously court trials can be public. You've got the relationship point of view. If you want to preserve a relationship there or not, but depending on how the parties feel about each other. There's an emotional toll, there's negative publicity and reputation, lots of different reasons why at different points in the timeline you might come to a settlement. But just a final point to note on this section is don't forget you might also have some court deadlines to abide by. So there might be different mechanisms, or there are different mechanisms that can be used to try and pressure someone to settle. And those might also come from a judge too. So a judge will always try to encourage that things are settled out of court because of the high caseload. So kind of wrapped up some reasons why someone might settle into that timeline there, Tori.
Cool. Thanks so much for that overview. I think that really equips our listeners with that kind of foundational knowledge to then really build upon that in the later sections. I also think it's just, really cool to go over, because a lot of our listeners have probably watched legal TV shows where there would be settlements reached. So I think it's nice to fill in the blanks of really what is actually going on when a settlement is reached. So I think we're ready to move in then to the intermediate section. So as a reminder to our listeners, when you're at an intermediate level of commercial awareness, this is when you really want to be considering why businesses care about this issue and what are the ways that law firms would assist in these contexts. So if we want to focus at this intermediate section about how law firms are really assisting clients when it comes to settlements, one of the things I was thinking about is that lawyers have this obligation to act in their client's best interests. And so how would a law firm be advising a client in pursuit of their best interests when it comes to settlements? What are the things that they would be thinking about?
The most obvious one that comes to mind for me is the costs, like we've already highlighted. So if I was advising a client, or anyone, future listeners, if you're advising your clients as to whether to settle or not, you've got to look at the implication, like the money and the damages side. So the reason why there's other things that go into settlements, but if we're thinking it's mainly for financial recovery, where possible, you've got to think about the actual money that someone's going to get in their hands at the end of it. So if you're going to go to court and you're going to spend millions and millions and then lose, and the lawyer knows that there's a high likelihood that you're not going to win in court, but the lawyer advises that you go to court because the law firm might get more money out of that because they're getting more hours billed, that would not be acting in the best interest of your client. You've still got this duty ethically and morally to make sure that you're giving them the best advice. So that would go into weighing up the financial implications of it. Another way is the emotional toll that we mentioned within the reasons why you might settle. As a law firm advisor, you will know your client in terms of how well they can handle a case. So we've mentioned some high profile ones, but for example, in family law cases, for example, it might be so extremely difficult for somebody to stand up in court in front of a perpetrator, or the other party that they are pursuing against. They might crumble, and then that might unfortunately impact the success rate of the case. So it might be much better to advise them to settle as well. So as lawyers, we're expected to think about all these different things, that the client's goals, the client's needs, getting consent to do this, lots of different things, but you've got to make sure that you are advising in the best interests of the client and not the commercial side of your role as a lawyer.
Yeah, I think that's so great to highlight, because of course we're focused on commercial awareness here and building that commercial thinking, but the professional obligations which are owed to clients are really critical to think about as well. So it's not commercial interests above all else. It really is so important that lawyers be working in the best interests of their client. Something related to this kind of best interest thing, something that I always think is really interesting when we're thinking about commercial awareness, is reputation management as well. So how does that come into settlement agreements?
So you've got reputation management of the firm, of course, and then reputation management of the parties as well. And it's good that you've asked about the ethical one up front, Tori, and weighing that up against the commercial side, because you think reputationally, you've got to think about all of that amongst everything. And again, listeners, don't panic, because this will start to come naturally to you, and you'll have support, you'll have supervisors that you can help you manage all of these things. But you've got to be really careful with avoiding any settlement that would harm the firm's reputation. So if you agree to something that is going to, be high profile, and then the firm's connected to advising on that, and it's just not great in terms of the conduct, or a bit borderline controversial, for example, but also the client's public image. So a lot of these high profile settlements that we're looking at, you've got to think about their image too, and the reputation of things and how it's all managed. And there's a lot more that goes into the comms, the communication side of settlements too. And quite commonly, a great way to manage reputation is to put a clause in the settlement. You might be surprised to hear that there are very commonly clauses in settlements about how things will be communicated and how they won't. And it's a contractual condition precedent of the settlement being paid or not. So there will be a certain statement in these exact words released on this date about X, Y, Z, and the parties agree between them. That's just a really, sometimes you see the statements made and it's like you think it's come from the person, it might not have done. So every time you see something like that, now you're going to be wary, is that in a settlement agreement contract? It might be. Certain restrictions about what you can say about it and what you can't and who can know, and lots of different things. Who knows? Freddie's documentary with Disney, for those that have seen it, it didn't actually show the footage of the crash. It just showed like a build up and then different effects on it. And I can imagine he was restrained as to a certain amount of what he can share, what he can't. It's important for him to be able to share it because it's his life, it's his face, it's quite clearly it's impacted him. But also he's had a payout for it by the looks of things, and there's got to be some protections from the other party as well as to what you can share, what you can't. That's all reputation management, and it will likely be documented formally somewhere.
Thank you. Yeah, I just always find this such an interesting side of commercial awareness because I think we think so much about the legal side of things. But I think, considering comms and, those statements, I just think is so fascinating. I have one more question at this intermediate level. I think this one kind of straddles the line actually between intermediate and advanced. So I think it's a good one to move us into advanced soon. It's about the timing and the strategy of settlement agreements. So really, what is the kind of strategy that goes into advising clients on what is the right time to settle?
That's another great question, and also leads into, like you say, the commercial arm of a lawyer's role as opposed to just the legal. So obviously we are brushing over the fact that this is going to be incredibly complex drafting and the advice and the emails that are going to and fro. There's a lot of legal work in this, but also the timing and the strategy. This is what will set you apart. And the listeners, if you can mention this or allude to it in your interviews or your applications and things like that, to say, well, actually, this is really important. It's a key part of legal advice as to when we actually settling at the right time, because it can massively impact the deal. It can impact the outcome. You need to settle at the time where the other side feels obviously at the most pressure to do so. So you've got them agreeing to things that are in your client's favour when we're thinking about those best interest things. But you also don't want to undermine negotiation leverage. You don't want to go too far and make them feel like you're bluffing in terms of litigation, things like that. So if you're threatening court proceedings and saying the only way we can get out of this is settling, but then you don't pursue the court proceedings years and years later, they'll call your bluff and say it's not working. So it's all about that exact right timing. You don't want to prematurely close off a better outcome, so you don't want to settle too soon. And it's about weighing up those benefits of, time, emotional toll, reputation, and everything else alongside this timing and strategy. There is a legal mechanism called a Part 36, which we would need a whole lecture hour or two to go through in terms of what that entails. Those that know about it will be nodding and saying, please don't talk about it anyway, because it's just really complicated. But I wanted to highlight it here as there's way more than just thinking about back and forth in comms or emails around when there's way more to this. It's more like a game of chess as opposed to just going, oh, when do we settle, when don't we? Because if you're commencing or you have a view of commencing court proceedings or in the middle of a court proceeding, there is a way that you can try and get a higher settlement out of the party and put pressure on them, and that's by way of a Part 36. So if you make a certain offer to settle, let's use simple numbers like 10,000, and this is a really simple overview, so those that are well versed in this will spot lots of different ifs and buts in this, but say if you offer £10,000 to settle and the other side doesn't beat that in court, then there are consequences of doing that if it's documented by way of a formal Part 36 offer. but the Part 36 templates and the way it has to be served is very clear legal requirements to that as to what needs to make it valid. So there's all sorts of legal advice that goes into that too. So if you're aware of them, great. If you want to brush up on them, I would do so. But it's also a good point in mentioning, because we've been talking a lot about the commercial side, how the legal strategy and mechanisms that you can use to push or force a settlement or add pressure can come to light with the timing and the strategy of these things.
Thank you. Honestly, I love that you brought up Part 36 because it's a big part of the SQE, actually. So for anyone who's listening who has the SQE in their future, who has just heard of Part 36 for the first time, you will soon know lots about it in dispute resolution. I think it's super interesting. And I think it is really important to mention here, actually, because as you say, like the way that Part 36 operates is that it would basically penalize a party for turning down a good offer. So I think it is really important to mention when we think about the strategy of lawyers advising their clients whether to accept a settlement offer or not. So yeah, I'm really glad you mentioned it, even though it is quite complicated. Was there anything you wanted to say at this intermediate stage before we move on to the advanced section?
Thank you for asking. I think it's just to wrap up and say it's really interesting. Let's use Part 36 to see how the academic side of law will meet the practice. And that's why I love that we're talking about these things, because usually with the academic side, you'll start with Part 36, this is what you need to learn. But what we're doing here today is we're talking about the commercial side of breaking down a big news story or a few like we've got today, and then seeing how that actually works in practice. So it's good to see both together. So I like how we've come to that juncture. And if people are listening and feeling like, and I know that lots of you enjoy this this format that we go through, but it might be a bit different to how you are being taught it. That's the whole point, is because we're trying to get you to think like a commercial lawyer, think commercially, and look at actually what happens in practice. And it's exactly why I love doing it this way. So I'm glad that we've married those together, even this early on in the session today.
For sure. I think that is one of the most fun parts of developing your commercial awareness, actually, is connecting all these things that you're learning in class to the real world and then seeing how that could play out in your career. I think it is just actually really exciting to make it practical. So if we turn then into the advanced section. So as a reminder to our listeners, at the advanced level, really here you want to be thinking strategically, long-term. How are lawyers strategic legal advisors? So I wanted to ask Emma, what kind of proactive advice might a law firm give to clients in this situation?
So gosh, there's lots of proactive advice that you could give in situations. Hopefully Tori comes back to us in a minute. I'll continue with this and we'll see where we get to. There's lots of proactive advice.
I am here. There was someone cutting the grass outside, so I had to close the window, but I'm here.
There's some proactive advice that you can give to hopefully avoid coming to a huge settlement situation like this. This costs businesses lots of money and they can face a lot of scrutiny. The BBC have had to come out and say that the settlement that's paid to Freddie hasn't come out of public money, for example. Imagine the backlash of that. So what law firms could be doing and will be doing is advising on health and safety practices, making sure that they understand that a risk evaluation needs to take place in relation to personal injury with things on set, looking at the strength of any particular claim that might result out of this. So it's just trying to, before you get to that point of damage incurring, there's lots of advice that law firms are giving to businesses daily on things, and it's all, well, the majority of it will be to avoid a future claim. And that's why we are so important, and we should blow our own trumpets, because that's what we're here for. We are there to hopefully stop these claims from arising. Unfortunately, it still does happen. So when you get to that point, the proactive advice would be, as soon as the BBC, for example, spoke to a legal team or a legal advisor about it, well, what can you do now to make sure that it won't happen again? What could you have done differently? And then how could you use that as an example in this case and say, well, we have made sure our practices are now X, Y, Z. There's lots of different things. And you might think, well, what's that got to do with the law? Well, in the background, the lawyer at the law firm or internal BBC is looking at the regulations for health and safety and looking at the risk evaluations and having input into all of those. You don't necessarily find it easy to connect the legal point to things like this, but that's where the work is. It needs some sort of legal interpretation. So there's that, making sure that that advice comes there, ensuring that everything's completed under health and safety and employment law. But do note, we're in the advanced section now, so we'll go there, that I don't think Freddie was an employee at the time. I think a lot of these high profile individuals work as freelance. So if you're into your employment law, major distinction there. Make sure you know what the individual's rights are as either employee or worker, because they do differ and they change. Health and safety, of course, overrides it, but don't trip up in interview and mention employment in the sense that it might be a strict employer-employee relationship. If it's not, just a quick side note there. And then another proactive thing, it's just encouraging early engagement in settlement, just trying to get it going as soon as possible, because things could escalate, liability could arise the more it's looked into, disclosure before you get to disclosure in court and things like that. So another reason why you might want to settle is to avoid those things. So lots of key themes and that link to this proactivity of advice, but those are a few things that law firms can be doing.
Thank you. I liked your side note as well about employee, like the distinguishing whether a person's an employee or not, was a flashback to tort law. So the next thing I was wondering about, because we were talking a bit about how in the intermediate section, we were kind of jumping quickly over some of the complex legal work that goes into this. So I wanted to maybe give you the opportunity to talk more about, basically what makes a well-drafted settlement agreement. And I guess a bit more broadly is, how can law firms be giving this legal advice that is really helping their clients gain a competitive advantage? Like, how can they really be advising clients in a way that helps them in that way?
So let's start with a realistic point. Settlement agreements in the main as templates are not complicated. So every law firm, I imagine, has got their own template settlement agreement sat there, ready to be populated and amended to fit the situation. Because just as any commercial contract, there will be standard boilerplate clauses. It will say settlement agreement at the top. It will have the parties. It will outline the claim to be settled. That's a very important point, by the way, around competitive advantage and things like that, because the definition of the claim and the dispute that's being settled is very important. Because if you make that too wide, you are settling everything. So if there's complications with things afterwards, so for example, if Harry, Prince Harry, would have discovered something else to do with the phone hacking later on, that settlement agreement will be pulled out, and it might say every phone hacking from this company is being from the news company, the publisher, is being settled. Or it might say the phone hacking of, let's say, I don't know the year off the top of my head, let's say 2018 of this month, that's when, or of this duration when it happened, that's what's been settled. So can you see the competitive advantage, the difference in what a law firm can do and advise upon with a well-drafted settlement? Because it depends what you're actually settling within that. So underneath that dispute that's been settled, you'll have the terms of what needs to happen to settle it. So the defendant will pay the claimant X amount of million within 30 days of receiving an invoice, and you might have tax things within it and lots of different things like that. So every law firm, what I'm trying to say, will have this, but the nuance comes in those examples that I've just thrown in there around, well, what makes it well drafted? And what makes it well drafted is about thinking outside of the box. So we mentioned earlier about, well, does Freddie want to retain the right to still talk about this in future? Because he's clearly made some money out of the Disney documentary, you would guess. That should have had some sort of foresight from the lawyer, because if there was a complete confidentiality clause, which is a little bit further down, technically, usually a little bit further down, no one can discuss anything to do with the crash whatsoever. And Freddie might be in his own home and he can't even talk about what happened to his own wife. There's things like that you need to be careful of. So that a well-drafted settlement is absolutely key. And it will include these structure clauses, so about liability, confidentiality, all the things that we discussed so far. I suppose managing a dispute effectively and privately, you can also avoid further public scrutiny. So we haven't seen and we don't know the details of what actually happened in each of these. To a certain extent, some might be more public, because as rightly so, we should never see the wording of that settlement agreement. It's not for the public eyes. So the client can gain a competitive advantage there as well if the law firm keeps it under wraps enough and is a great advisor to make sure that that expert legal advice has been given in a way to mean that it's under wraps, we've managed it, we'll settle it, and we'll move on. If it's prolonged and it becomes too public and there is too much hoo-ha about it and it's not being kept under wraps, then of course it's going to be more difficult for the clients as well. So you've also got to think BBC have got a reputation to uphold, Mastercard have, just as NGN News have. None of them have faced, apart from the actual issue, a huge, decline because of what's happened, I don't think. And that's because it's been handled quite well, and you would expect a lawyer to be able to do that. So that was a kind of complicated way of explaining and bringing the two together. I hope that makes sense. But yeah, there's lots of different ways that you can think about your client's commercial and competitive interests as well within a settlement.
Yeah, that absolutely makes sense. One final question for you, because at this advanced stage, we're thinking as well about thinking long term. And I think also equipping listeners with this kind of ability to reflect on long-term trends really helps in interviews and applications. So could you just explain what kind of broader trends might be relevant here?
It's always a good question to finish on, isn't it? Thank you, Tori. Because, of course, there's a lot of scrutiny around these settlements sometimes because they are so high profile. And the more quiet they are kept, the more speculation might happen. So what actually did happen there? And I would expect listeners to be thinking about this from now on, like, I wonder what was written in that contract. So we've got public and regulatory expectations around accountability, of safety. You've got media and entertainment who seem to be pushing the boundaries at the moment. Should that be at the expense of others? Absolutely not. And people need to make sure that they are under pressure to act really quickly and make sure that they are protecting individuals in certain circumstances. And I know that there's different facts in each of the cases that we've mentioned, and the Google one that you have, Tori, and those that people have in their own minds. But we need to make sure that the health and safety is front and foremost of people who are involved in things like this, and everyone's rights are protected, including data protection is protected, etc. There's also the social media part of things, so you can comment on unfortunately or fortunately, it depends on which side, but on what happened. And even though the settlement itself should be confidential, actually what happened isn't, with a lot of these cases, because it ends up in the news and then you've got the public who can comment on it. And then, having strong internal systems for managing incidents and having legal involvement. Some of the things that you can do to prepare for the future is making sure you have a strategy on how you deal with settlements and how you would like to allocate your risk, and if you are willing to go to court about something to fight your corner, or if you have a certain attitude towards settlements. And I do think, just to wrap up here, that there is a trend, especially now because of social media and other things that we've mentioned, to settle rather than go to court. I think we'll start to see a lot more things going under the radar and being settled than we ever have before.
Yeah, I think that makes sense with how widely things can be shared on social media. Thank you so much for providing that overview and for all of your insights today. I've really enjoyed the conversation because, again, I think that settlement agreements really are such a great thing to talk about when you're considering a commercial awareness question, because there is just so much to discuss. So thank you, Emma, for sharing your insights, and thank you to our listeners for joining today's Commercial Awareness Compass. Remember always that commercial awareness is more than just staying on top of the news. It's not about regurgitating headlines. It's about understanding why these events matter to clients and how you, as a future lawyer, can provide that strategic value. So join us next week to continue building your commercial awareness. And until then, prepare without the panic.